We do have a few people still coming in, so I'll start with some general remarks. I'm Michelle Thompson, the current president of UIC SUAA, and for those of you who may be guests today, the UIC chapter of the State Universities Annuitants Association is a very active chapter here at UIC, and we're very happy to see so many of you here today. The mission of SUAA, SUAA, is to advocate for the preservation of benefits for employees and retirees. And we have a statewide office with an executive director who is right over here. Linda Brookhart is standing in the aisle here. Linda has an office near the Capitol in Springfield and is daily in contact with legislators explaining the principles of the benefit system in the state public universities in Illinois and advocating for us in defense of all of the benefits that we have been guaranteed and have contributed to over the years. And she will be hard at work on Monday as the veto session begins in Springfield. So watching all those 400 plus bills that normally pass through the legislature every year is Linda's job, and she produces, for those of us who are members, we know briefings about the status of legislation that may affect our status as retirees and employees. So we do advocate, as our brochure says, defending your benefits is the purpose of SUAA, and the UIC chapter is very active in doing so. For those of you who might not be members, we hope you will join us, and there are membership materials on the table out front. We want to welcome today our guest speaker, Charles Slamar, who will be our first presenter, and we're very grateful to him for coming to meet with us today and share his expertise about estate planning. The matter of estate planning is something most of us have thought about, and we intend to make clear to all of our family members at some point, and some of us have made starts at that, and it's only later on that we find out that there are a few loose ends and things we might have tended to or informed family members about. And so Mr. Slamar is going to help us identify those items that we might want to give attention to, particularly to have ourselves assured that in the need of care or special considerations, our family members know about our wishes, and for when we're gone, that they are helped in terms of clearly understanding our wishes. We see many publications about estate planning today, from the daily newspaper to special television presentations to the AARP newsletter to the Wall Street Journal, and the snippets of what we ought to consider are all over the place, but an organized presentation of what we ought to be thinking about or might want to be thinking about is a little more difficult. And our other speaker, Arlene Norsym, whom you all know from this campus, has been, as none of us will be surprised, dutifully approaching this for several years and organizing all. So she's going to share her personal experiences with how she got started, what's been useful, what resources have been available to her, and give us some practical advice about how one motivates oneself. This program is one part of what the UIC chapter of SUAA does every year. In addition to advocating, your board members meet with the legislators in the Chicago area and in the suburbs to inform them, one might say educate them about the State Universities Annuitants Association, the issues that are most important to employees and retirees. And so the advocacy role is very important. In addition, the UIC chapter seeks to bring information to our members and to those who are interested who might become members. And each year we have an annual fall forum. This is the 2019 fall forum. and it has a topic, the Fall Forum, and we hope to bring something of note and concern to our members at this time every year. In addition, we have a fall meeting, this is the fall meeting, we have a spring meeting that is our annual meeting to report to the membership. We also invite guests to that. And the topic you will remember from last spring was a very interesting presentation by Professor Jay Olshansky at UIC about health planning and aging. I want to thank several members of our board for work on this fall forum. You met Karen Sherman and Debbie Matthews in the front. They're the people who pull the program together, make all the arrangements, and quietly and willingly assume responsibilities that to some of us seem to just happen. Also, I want to thank Arlene Norsym and Elliot Dudnick, whom you've met, for their gift of time and effort. They've spent a great deal of time this summer preparing for this. And Arlene, as you know, is retired as the Associate Chancellor for Alumni Relations. Elliot is Professor Emeritus in the School of Architecture. And they've been unstinting in their time in planning for this. In addition, we would not have our guest speaker were it not for the efforts of Chris Keys. And Chris is responsible for identifying Mr. Slamar and encouraging him to come share his expertise with us today. Someone who is not with us today is Merrill Gassman. He's our chair of the Communications Committee and the webmaster who has distributed and publicized information about this regularly. And also Sonia Booth, who produces our newsletter that members receive several times a year, has also publicized this event. So with gratitude to all of those people, and I want to welcome you again, I would like to turn the program over to the moderator, who is Professor Elliot Dudnick.
Not much to add. I'm sure you all wanted to be at the budget hearings for the city of Chicago, which are happening simultaneously. I was listening to them coming down. As you can tell, the overall topic, which was advertised, is "Don't leave a mess for your family." Basic instructions, which is pretty scary. I've gone through this within the last number of years, and it's either not fun or even worse. So I think everything you're going to learn today is going to be worthwhile. For those who still remember your classroom days, start taking notes now. One thing I would actually, I don't know if we're going to have copies of the talk, so I'm not sure quite how we're going to do this. So the first speaker, as you know, is up there, Charles Slamar. I'm still not sure if I should say Slamar. And then followed by Arlene. And afterwards, we're going to try to entertain as many questions as we can. Somehow, magically, there will be cards that will be passed out amongst you, or they'll be available so that you can write down questions and all the rest, and then we'll pass them up to the front and try to give it to the right person. With that, let me just try to introduce Mr. Slamar. He, as you might have guessed, is an attorney. He's a graduate of some university downstate. I'm not sure why he went there, but maybe there wasn't a UIC campus, or when even at Navy Pier at that time. So he graduated, he got his BA at UIUC, got his law degree from Loyola, and then got what I had to look up, an LLM with a specialty in taxation from John Marshall. So he's got certain relationships to this campus. For those who don't know, an LLM is a second law degree that you can apparently only get once you've done the JD and passed the bar. There's trivia that everybody's going to write down, of course. In his private practice, he advises individuals on taxes, estate and charitable planning, and charitable organizations on gift planning and litigation. And he is with, as it says there, Thompson and Associates, which is a charitable estate planning firm. And I think a lot of the work, if not all of that, is with nonprofits, as best I can tell. He worked for about 18 years at Bank of America, where he was the philanthropic regional executive, and 9 years as director of estate planning services for what was probably then called Children's Memorial, now known as the Lurie Children's Hospital. And he helped design and implement their planned giving program. So when all of us, and I suspect all of you, get things in the mail now, I seem to be getting more and more of those that also ask me whether I want to give them gifts and get annuities and all the rest. We can attribute it all to him. He was a founding member of the Chicago Council on Planned Giving and twice their president, and has served on the board of the National Committee on Planned Giving. You can see the pattern. And he's also been on the faculty of what's known as the Association for Healthcare Philanthropy, something called the Madison Institute, and the Charitable Estate Planning Institute. And he co-edited and was an author of Message from the Masters, which was a compilation of donor stories by prominent charitable gift givers. And finally, he's the past secretary and director of the Chicago High School for the Arts, which is the only school, I didn't know that, the only public school offering both college prep and pre-professional arts training. And apparently its genesis came from a foundation that he once administered. They must be closed this week.
I think they are.
So, I don't know if you were supposed to be on strike or not. Whatever. Anyway, the topic, as you can see, are the three most important questions the best estate plan will answer, and I think it will for many of you. I've seen it. Thank you.
Thank you, Michelle. Thank you, Elliot. Thank you for the rundown of the degrees. As my wife will tell you, a degree is evidence of your competency, and sometimes it's the only evidence. All right, so to begin, I want you to think about what would happen if you suddenly had a large sum of money and couldn't spend any of it on yourself. Think about that. Who would you give it to? Would you give it to one person? Would you give it to a number of people? Would you give it to family, friends, charity? When would you give it to them? All at once? Over a period of years? Sometime in the future? And then what would you say when you gave it to them? Nothing? I'd like you to use this for, thank you for, God bless. Well, this will happen. Because when we die, there's going to be a large sum of money that we can't possibly spend on ourselves. And I remember John McCain toward the end of his life saying that, I always thought an exception would be made in my case, but I'm realizing it's not. And then I also remember a couple of years ago reading about the fact that there was a study done that people who read mystery novels, they actually enjoy them more if they know the ending. So to enjoy your life more, I'm going to tell you how it ends. All right. So as The Onion once said, the U.S. death rate has remained constant 100%. So here are the 3 questions that I think the best estate plan will answer. The first is, do I have enough to live on for the rest of my life? Consider, do my assets and income meet or exceed what I need for financial independence? And what does financial independence mean? That's up to you. I mean, I've met with people that says, well, as long as I'm working, I'm financially independent. Or my retirement assets are going to take care of me. I'm financially independent. I don't need Social Security. I don't need my pension, or I do. Whatever it is for you, that's the first question. Because you can't think about giving anything away unless you make sure you got enough for yourself. Okay, second question, and here's the naughty question, as we say. How much and when should I give my heirs? And it's not just heirs, it's the people who you care about. It's the organizations that you care about. So consider, how would a lump sum inheritance affect my loved ones? How much is too much? How should it be given? And when should it be given? And then does a trust make sense for my family? A trust is a legal entity. I've got the parameters here. Trustee holds legal title, created on life or death, revocable or irrevocable. Oh, and by the way, if you want copies of these handouts, just leave your name at the front desk. They've got them, so they can send them to you. Quote them as you like. Take responsibility for the mistakes, but not the right stuff is mine. Okay. Trusts used to be that people would do it more for tax planning, but they are very good for creditor protection. So for example, I can create a trust for myself, but it's subject to the claims of creditors. I can create a trust for my daughter's benefit using my money to benefit her, and that is exempt from the claims of her creditors. Well, who are my daughter's creditors? Well, they could be people who she owes money to. It could be her divorcing spouse. It could be herself if she develops bad habits in terms of spending money, alcohol, drugs. So it's a way to protect people. It's a way also to encourage behavior. Rather than getting a lump sum at a certain time, people were saying, well, I wanted to get so much at X, so much at Y age, and so much then. And as one of my clients told me, if I haven't instilled my values in them by then, I never will. So that's another reason for setting up a trust. It also helps you to avoid probate. What's probate? Probate is a court-supervised distribution of decedent's assets and payment of their debts. And it's done pursuant to either the decedent's will or the state intestacy laws. The state intestacy laws are not as nefarious as you might think. They try to duplicate what they think a decedent would want. They give preference to a family member and the family member. There may be costs involved. I'm sure you've heard about, the cost of probate. Yeah, but you can waive some of those costs, like a bond and the like. I will suggest to you that when you hear all these horror stories about the cost involved in probate, that was the transfer of the assets. Those were involved in transferring the assets. It does shorten the statute of limitations. Generally, a creditor has 2 years from the date of death of the decedent to bring a lawsuit. But with a probate, it's 6 months from either notice that the debt is due or publication. What I have found helpful about probate is it provides a forum for disputes about either the distribution of assets or the payment of debts. The one downside is it's public, but there are ways you can get around that too with just giving a general amount of what would be subject to probate. And then the last question is, would I rather my executor or trustee write a check to the IRS or to my favorite charity? Because you're going to find out that there are 3 potential beneficiaries of your estate plan: family and friends, government, and charity. And you get to pick 2. Okay, so let's consider social capital. There are certain dollars that you cannot possibly pass on to your heirs or other individuals. These are monies that are taken by taxes, either income tax or estate tax. And these are essentially used for public purposes. The federal exemption amount is a whopping $11.4 million. That's going to go up to $11.49 or $5 million next year. Almost $23 million can pass estate tax free from a family down to their heirs. Indeed, it used to be that 5 deaths for every 1,000 were subject to the federal estate tax. Now it's 2 deaths for every 1,000 is subject. Most people are not, do not have to pay federal estate tax. However, Illinois is one of the few states that has its own estate tax. That amount is $4 million. Still, not many people are subject to that. And it's true that most of us will not pay either federal or Illinois estate tax, but there could be taxes due on or after your death. Okay, I'm going to date myself. Remember Itsy Bitsy Teeny Weeny Yellow Pocket? Yeah. Well, stick around. We'll tell you more. Okay. So, my point is that millions of dollars are wasted every year on unnecessary taxes and estate settlement costs due to lack of planning. Okay? These dollars could have gone to family members, friends, or worthwhile charity causes. So, how can you avoid unnecessary hassles, costs, taxes, and stress? Enhance and protect your estate for loved ones. Provide support for your favorite charities. 3 reasons, 3 opportunities. Work with a qualified estate planning attorney. With all due respect, don't go to your real estate attorney if he does or he or she doesn't do estate planning. We're dealing with a trust now that was written by the decedent's DUI attorney. And you can imagine there were some issues with that. Attorneys are required to recommend what's in your best interest. It's not at all unlike, I would suggest you can interview attorneys just like anyone else and find who you're comfortable with. The initial conference shouldn't cost you anything. And I tell the story, I had a client who had hundreds of millions of dollars, and they were going through a beauty pageant, so to speak, in terms of who they were going to use for their fiduciary in this case. And the wife told me later, she said about halfway through the process, he turns to me and he says, "What do you think?" And she says, "What do you mean, what do I think?" He says, "Well," he says, "I'm probably going to predecease you. And so you're going to have to live with this." And I don't want to sound sexist, but in estate planning, it's the men who plan and the women who live with it. And indeed, 85% of the husbands predecease their wives. So it's your estate plan. Make sure you know what's involved. And her point then was, she said it changed everything for me because I figured everybody was equally smart and it was who do I want to deal with? And it was who do you want to deal with? Who do you feel comfortable with? Because once you do your estate plan, you're not done. Things change. Families change. Tax laws change. Circumstances change. So you're going to want to make sure that your will, and if you have a trust, that they're up to date. Beware of online forms. I'm a lawyer. I got a bias. But I recently had a situation where a woman had an online form and it said, "To my 2 daughters or the survivor thereof." It turned out that one of her daughters had children. And I said, "Well, what if she should predecease you? Do you want your grandchildren to get it?" "Well, of course. That's not what your will says. Because it says, or the survivor thereof." The other thing is to making sure it's executed properly, that you have the proper witnesses, that you have, and it's executed in the correct manner. Okay, so what I think you need is a will, maybe a revocable living trust, a healthcare power of attorney, a property power of attorney, and a living will. Healthcare power of attorney designates someone to make decisions for you if you're unable to. Okay? you're unconscious. You can't make those decisions. My daughter is my wife's successor healthcare power of attorney. She's a young kid, 30. But she says, all right, no life-saving measures, Dad. What does this really mean? So, okay, Kristen, you ask the doctor. Can he drink scotch and still enjoy it? Can he watch baseball and understand what's going on? If the answer to either of those questions is no, pull the plug. And then, of course, property power of attorney. People think either A, I'm going to live, or B, I'm going to die. Nobody, or very few people, consider you can be disabled and can't make decisions for yourself. How do you get access to your accounts to get the money that you may need to pay for bills, to pay for expenses and the like? So you want a property power of attorney. A living will is a will that's executed just like a regular will, but it takes place in the event, it becomes effective in the event you become unconscious, can't make decisions for yourself, the doctor has determined you're in a terminal condition, and there's no hope for you coming out of it. And this just directs, I want no life-saving measures except to keep me comfortable and as pain-free as possible. So these are the 5 documents that I would suggest you consider having. Some people would say, well, if you got the healthcare power of attorney, you don't need the living will. To me, I don't charge for the living will, and what if you can't find the agents for the healthcare power of attorney? So you've got the living will, okay? You need to coordinate this with how assets are titled, beneficiary designations, and then we'll talk a little bit about the difference between gross estate and probate estate. Okay, so to talk about why you need to coordinate this. My wife and I have what's called I love you wills. Everything to my wife, if I die first, everything to me if she dies first. But let's assume we have a terrible argument. And I rewrite my will. And I name my best friend Leo, who's the only person who's really understood me the last 40 years, and I name him as the beneficiary of my will. He gets everything. Everything's properly executed, notarized, and the like. He takes it to the courthouse. Charlie's dead. I get everything. He's not getting anything. And let's avoid for the moment, you cannot disinherit a spouse in Illinois, but let's assume you could. Okay, even though I've got a valid will, Leo's not getting anything. And here's why. Our home is tenant's entirety, which means when I die, my wife gets it automatically. Our bank accounts, our brokerage accounts, our joint tenancy, which means when I die, she gets it automatically. My retirement account, she's the primary beneficiary, which means when I die, she's going to get most of it. So there's nothing in my estate that's going to be directed or passed pursuant to my will because of beneficiary designation and the like. And I've seen places or instances where people spend tens of thousands of dollars and they've written their will and they have a trust and it's beautiful tax planning and everything is still in joint tenancy. I said, nothing's going to go pursuant to your will. So you want to make sure that it's coordinated. Then we talk about the difference between a gross estate and a probate estate. A gross estate is everything that you own. Everything. Jointly owned property, irrevocable living trust, life insurance, retirement. A probate estate is just those assets that are in your name alone. Or if you have a beneficiary designation, payable to your estate. All right. So these two estates, you have the total gross estate plus your probate estate. That equals or includable the probate estate. That's your taxable estate. And as I said, most of us will never pay estate taxes. But there are assets, generally, when I inherit or get an asset by death or by gift, that is not subject to income tax, or estate tax, or income tax. So if I give my daughter $1,000 worth of stock, that is not subject to income tax to her, okay? If I give her real estate, that's not subject to income tax to her. However, there is an exception to this general rule, and these are called IRD assets, income in respect of decedent assets. These are assets that there's income being due, but it comes due after your death. So let's assume you get paid on the 1st and the 15th, you die on the 7th. You're going to get that money that's due you from the 1st to the 7th, even though it's going to be paid on the 15th. That's income in respect of decedent. I've got a stock that has a dividend payable date or payable to record holders as of a certain date, but it's payable as of a later date. If I'm alive on that date, I'm entitled to that dividend. That's income in respect of decedent. The biggest items that are income in respect of decedent assets, IRD assets, are qualified retirement plans, individual retirement plans, U.S. savings bonds, and commercial annuities. These are great income tax deferral devices. They are lousy, and that's a legal term. They are lousy wealth transfer devices, and this is why. Let's take a look at Mary's estate. Personal residence, stocks, bonds, life insurance, IRA. $600,000 total estate. Well below the federal exemption amount and the estate Illinois exemption amount. However, she's going to pay tax. If not her, when she starts taking it out after her death, her heirs. And I've used the median income tax rate, so that $300,000, that's going to be reduced by $72,000, which is the income tax that is going to be due on that distribution. That's 12% of her estate. Not subject to federal, not subject to state, but 12% of her estate. Suppose she wants to leave 10% of her estate to charity. If it's paid out of other assets than the IRA, it doesn't eliminate the income taxes. So it reduces the net to the heirs to $468,000. 10% of Mary's estate is 20% of her IRA. So what I suggest she does is take 20% of her IRA and have that payable directly to her charities. She reduces the income tax to $57,600, and she's increased the net to her heirs. Now, she's going to have to keep track of what those values are to make sure that 20% of her IRA is indeed 10% of her estate, but it's a small price to pay. And it's a lot easier to change an IRA beneficiary designation than it is to change your will or your trust. And then, don't forget the IRA charitable rollover. If Mary is 70.5 or older, she can direct up to $100,000 from her IRA directly to her favorite charities. Okay? There's no income tax deduction, but that distribution to Mary is not subject to income tax as well. And with all due respect, if you're 70.5 or older and you're making charitable gifts, if you're not doing it out of your IRA, you're not as smart as you think you are. Okay, so here are some qualifications. It has to be paid directly from the IRA custodian to your favorite charity. Their IRA custodian is going to usually want to know the name, the address, and the tax ID number of the charity. This is easy to get. It counts toward your minimum distribution, but regardless of what your minimum distribution is, you can pay out up to $100,000. Okay? It's reported as a normal distribution on your 1099, so you'll get your 1099, which will show the total distribution. But when you go to report it on your 1040, you show a QCD amount, which is the amount you pay to charity. QCD stands for Qualified Charitable Distribution. Okay? So that amount is exempt from the income tax, and some charities are not eligible. Private foundations, supporting organizations, donor advised funds. University of Illinois Chicago Circle is a qualified charity to do this. So if you have any charitable intent, this is a real easy way of making that gift. And indeed, most people, they try to defer the IRA payout. So this is a really nice way of getting that payment done. Okay, the other thing is that this is tax efficient charitable giving. So if I give $10,000 of cash, I write a check for $10,000 to UICC, and I'll get the same tax deduction as if I had given them stock worth $10,000. However, with the check, I'm out of pocket the amount of that check, $10,000. With the long-term appreciated capital gain property, long-term is a year or longer, capital gain property, my cost is my basis, what I paid for it. And I do avoid, or I'll minimize, capital gain. So let's look at an example of this. Cash worth $10,000, cost me $10,000, no gain. Let's assume that I sell the $10,000 worth of stock. My basis is $7,000, I got a $3,000 gain, 20%, minimum $600 tax. You never want to do this because you don't have the asset to pay the tax. You want to give the asset directly. I was a charitable trust officer for 18 years, dealt with very, very sophisticated people. December, I get a call, Charlie, take $25,000 out of my investment account and send a check to XYZ charity. And I would say, look, you've got some stock that has that fair market value. Why don't you send that stock? Oh, but Charlie, I like that stock. Well, if you have the $10,000 or $25,000, why don't you buy that stock back? Look, if that stock then goes up to 12, and my basis here was 10, I've got a $2,000 gain with my new stock that I bought for 10. But if I had held on to it and gave the 10 in cash instead, I go to sell that stock, and I'm sorry for the misalignment here, but I got a $5,000 gain because my basis in the old stock is 7. If that stock goes down to 8, with my new stock and my new basis, I got a $2,000 loss. With my old stock and the old basis, I've got a $10,000 or $1,000 gain. As I said, very sophisticated and smart people. It never ceases to amaze me what an aha moment this is for folks. Okay, so suppose Mary wants to increase her annual income, make a charitable gift, and save taxes. Well, she can create a charitable gift annuity. Charitable gift annuity is a gift to a charitable organization, and in return for that gift, the charity agrees to pay you or another person income for life. The oldest one of these, John Trumbull. Who's heard of John Trumbull? John Trumbull was the painter of the American Revolution. He had all these paintings. He became destitute. He was selling off the paintings to sustain himself. He went to Yale. He said, if I give you all my paintings, will you pay me a stipend for the rest of my life? They did. And that's their art institute now, their art museum. John Trumbull. It goes back a long time. So let's assume that Mary's 75, takes that $10,000. Based on her age, she's going to get an annuity of 6.2%. A lot bigger rate than what interest rates and CDs are paying. Matter of fact, I had a client years ago, a donor years ago, who had treasury bills maturing. And she called me and she said, can you find out what other treasury bills and municipal bonds are paying? I did, and I said, but remember about charitable gift annuities? At that time, it was 14%. I remember I went to my finance director, he said, 14%? He said, there's no way we can pay that. And I said, yes, there is. I said, first of all, she's 90. She's got to live X number of years to get it. I said, but money markets at that time were paying 8%. So you add to that, she got a nice income for that. She also got a charitable deduction. And charitable deduction would be worth more for her than the state tax deduction. The other thing I want to tell you about her was she had named children's in her will. And I said, look, you are subconsciously living off the income that you have set aside for us. I said, you intend for that money to be there. Why don't you accelerate that gift? and turn it into a charitable gift annuity, you're going to get an income tax deduction. You're going to increase the yield from the $25,000 that you set aside, and the income tax deduction is going to do better than the estate tax deduction, which you wouldn't have. And not only did she like it so much, she did another one the following year, and when she did pass away, the hospital had a sizable gift from her. These are also good things to think about with the raising of the standard deduction. A lot of people now, they can't deduct because the standard deduction is so much. Well, here's a way with charitable that you can do a multiple of this, and you can see you might get above that amount. So of her annual income of $620, only $146 is treated as ordinary income. The rest is treated as a return of principal. As with any annuity, part of the money that's coming back is your money, okay? And until 2030, which is her life expectancy, and then it becomes all ordinary income. The rates for charitable gift annuities are not as attractive as commercial annuities, but the reason is it's a charitable gift. So you've done well by doing good. Okay? The other thing, suppose married children don't want her home, or they can't afford her home, or she has no children. Well, she can deed the home to her favorite charity and retain the right to live there for the rest of her life. And I've seen situations such as this, where they were going to leave, it was going to be an asset of the estate, and they were going to sell the real estate, and then make the distribution to the charity. So what she can do is she can have a retained life estate. She's still going to be responsible for maintenance, upkeep of the home, but she's going to get an immediate charitable income tax deduction for the present value of her retained life estate. So let's look at Mary. 75 years old. Remember, we said her house is worth $150,000. Let's say the value of the building is 125. The land is 25. They'll give you the software to compute this. She's got a $93,000 charitable gift deduction. That if she were otherwise unable to itemize, if she was taking standard deduction, this is a nice benefit. And I did have, so what if Mary needs to go into an assisted living facility? She can rent the home out, or she can gift the unused portion of her life estate and get another income tax deduction for that. Had a client, by the way, who did this, and for the charitable organization was my client. I got an email from the plan giving officer. By the way, had breakfast with Mr. Donor this morning. Couldn't thank me enough for taking care of this transaction. It resulted in a $170,000 gift to the charity. Nice deduction, which he could really make use of this year. Prior to my discussing the life estate with him, he was just going to leave his property to us through his trust and would not have been able to take advantage of the tax consequences. Tax advantage. So this is a way of accelerating those gifts and bringing those gifts forward and getting a benefit from it. So, if someone could show you how to make a charitable gift, decrease taxes, and increase income, would you be interested? There are people at your favorite charity who'd be more than happy to talk to you about how you can do this. Okay? So, in my experience, what I have found, there are 4 reasons why people do estate planning. First is, what if I die too soon? Second is, what if I live too long? And then, what will happen to those organizations and people that I care about? And then the last one is, how will I be remembered? And after the first 3 are taken care of, that's the eternal question. How will I be remembered? There is a charitable gift in my estate. And the reason I've done it is, although I love the organization, it's for my daughter. Because I want her to remember this is what your dad was about. If I had a choice between passing on to my daughter every dollar that I ever earned, or every valuable lesson that I was ever taught, I pass that on to her, the lesson. And indeed, as I've shared with her, if you can't live on 90% of your mother's and my estate, I don't know how you live on 100% of it. And I couldn't have been more proud of her answer. She'd say, hey, you guys paid for my education, we're cool. I'm not counting on anything. But this need to be remembered. is very important. I just read a review by A.O. Scott in the New York Times, and he talked about the fact that all loss is inevitable. He said not just lives, but experiences that become memories and then are forgotten. And taking that into account, the other thing that I do with my clients is I suggest to them that they write a letter to their beneficiaries. They write a letter telling them either life lessons, what those folks may know. My two stories in this regard is I had a client, a next door neighbor, who even after we moved away, we stayed close with. I met her granddaughter for the first time at her wake, and I'm telling her stories that Alberta had shared with me about her. And as I'm driving, her face just lit up, and as I'm driving home, I think it wouldn't have been so neat if Alberta had just written her a letter and said, these are the things that you meant to me. These are the life lessons I like to pass on to you. Closer to home, my younger sister passed away when she was 40. Her son was 5. He graduated from college 4 years ago. In the safe deposit box was a graduation card that she had signed for him. And it wasn't a sappy card because Millie was not a sappy person. It was a funny card. But as Adam said, boy, this is the best gift I could have gotten. And I encourage people to handwrite it. My parents died years ago. I can still picture their handwriting. So the need to be remembered, how do you want to be remembered? They're going to value that more than the will, the trust, the power of attorney. And so I'll leave you with this last quote. The desire for power in excess caused angels to fall. The desire for knowledge in excess caused a man to fall. But in charity is no excess. Neither man or angels will come into danger by it. Thank you very much.
I suspect everybody who's got question cards probably wants another couple of cards to ask more questions, but we are now going to move on, and our next speaker is Arlene Norsym. Many of you know her. As Michelle said, she was she's retired now, but she was the Associate Chancellor for Alumni Relations at UIC, and served for a very long, at least 3 chancellors.
Yes.
She named them all, but they're all beyond my time. She's actually a grad of UIC. She got her bachelor's in psych.
Yes.
And then got an MBA here. But somewhere between the two, she went to work for a number of years for a large accounting firm. She calls it one of the Big 8. Are they still Big 8s?
No, there were 6, there might be 4. Four.
And then she came back here for her MBA, and somewhere after that she worked for what is now the late Dean Paul Chung. Some of you may remember him, in the College of Engineering. She was there for 15 years. During the period where everything was happening, we became a Research One university. And at some point, by the time those 15 years were up, she was the Assistant Dean of Student and Alumni Affairs for the College of Engineering. And then she was appointed Vice President of the UI Alumni Association and the Associate Vice Chancellor for Alumni Affairs. She's also, of course, as some of you realize, a member of our board. I think you mentioned in an email the other day that we now have a separate UIC Alumni Association. She's very proud of that.
Yes.
I don't know how much you have to do with that. And Arlene is going to speak on all the other questions your family wished they had asked you. And I understand about that. I should say, as Charles was talking, all the benefits of trust really are benefits. Having gone through this 4 times within the last decade, individually, father, father-in-law, mother, mother-in-law, there are, I will say offhand, a great number of advantages to many of the things. I just haven't partaken in the charitable annuity and the charitable donation part of it to the extent. But as I said earlier, and I suspect a lot of you who give to charitable organizations now, if you're over 70, they seem to know. If you've started to look at your mail, for those who are involved in that, they're constantly now offering you this whole annuity plan, and they give you all the rates that you will get depending on your age. It's astonishing. I mean, 3 to 5 a day, I swear. I think I'll just stop giving them my address. And with that, let me, again, Arlene Norsym.
Thank you, Elliot. I appreciate that introduction, but I have to say that one of the things I'm most proud of is that I'm a 2-time graduate of this campus, and really grateful to those people who came before me to leave all the charity that would establish the institution that I could go to. I want to add my thanks for that wonderful presentation we just saw on topics that we all love: death and taxes, right? Well, I've subtitled my portion of this program, Lions and Tigers and Bears, oh my. I don't have a PowerPoint, but I did bring a few show and tell handouts, so you can now think that you're back in kindergarten. Michelle roped me into doing this and said that people love to hear stories, so now you're stuck. Here's mine. About 25 years ago, my husband and I heard a presentation, I think on the radio, if you remember what those were in those days. It was being offered that said, how to avoid probate. Read that, taxes. Use a living will and a trust. Avoid taxes? Sign us up. We went to this presentation. We're convinced, made an appointment, walked out of an attorney's office a few months later, that attorney shall be nameless, with a 4-inch binder that was jam-packed with more legalese than anyone should ever have to read. But it did include, I'm glad to say, the living will, a trust document, the health care power of attorney, and the financial power of attorney. But the other 3.5 inches, we didn't really need to read. Periodically, we would get a note from that attorney's office saying that it'd be time to review our documents. Oh, tax laws have changed, or maybe our family circumstance has changed, and so for a small fee, they'd be happy to have us back to talk about it. Well, we did that a couple times, and we asked questions about that 3.5 inches. Never really understood that stuff either. So this January, when I was again doing a periodic update of the white binder, which you will hear more about later, I thought, you know, we haven't really updated our trust documents or our will lately. So I called that office. I mean, they had our stuff. Oh, we'd be happy to review that with you for a small fee. And by the way, we've just finished digitizing all of our documents, and we lost yours. They didn't have a copy of our documents anymore. You won't be surprised to learn that we went quickly to find a new attorney who was more close, more reasonable, and in whom we have a lot more confidence. This is all we use now when we travel, and I reuse things. It says important documents on when we travel. It's all we need for our son needs or any doctor needs wherever we are. So, lesson number 1, keep it simple. And if you go to an attorney who offers you a 4-inch binder, my advice is get a second opinion. do some searching, as Charles said. Don't leave here today without a promise to yourself that you will make sure you have those 4 documents in hand, updated before the end of the year. We never know. But there is another part to avoiding a mess. So here's the second part of our story. John and I like to travel. And in my last opportunity here at the university, I got to travel a lot internationally. One year, it finally occurred to me that if something happened to us on those trips, our poor son would be adrift in a mass of papers and files with no Google map to help him navigate all the bits and pieces. He's of that generation where he depends on Google Maps. Now, he knew where a little firebox was, where the originals of these documents are, but it suddenly occurred to me that there might be other things he would need. For example, how did he reach our relatives and friends? Where was our birth certificate or marriage certificate? Did we have insurance policies on our lives, our home, our long-term care? What banks did we use? Did we have a pension, Social Security, credit card information? Where was it and what was it? And who were our doctors and what medication? And of course, where are all the passwords to those accounts? Talk about lions and tigers and bears. Anybody here besides Elliot who inherited a mess from someone in their family? So you know it can take a long time and a lot of agony. And you don't particularly look fondly upon that person for a while you're in the midst of it. I realized I needed to find a solution. I worked with engineers for 15 years, so, right? What do? You get organized. This is the affectionately called Norsym Family White Binder. That's the legal term. It's a very simple 3-ring, easily updated reference manual. Yes, we have a firebox. It's gotten a little bigger. It's a box now. I think that safe deposit boxes are fine, and we had one for a while, but where's the key? Did you lose the key? Is the bank still there, or did it merge, and what happened to that? So I trust in Providence and my firebox, and that's where all those important originals now are. While I was putting the book together, I started with what I thought were the obvious things. Family and friends' contact information, the insurance documents, pension and Social Security. But the more I thought about it and the more I talked to friends, the more I realized he would have questions like, who's your veterinarian? What credit cards do you have? Who does your income taxes? Do you pay your bills online? Where's your checkbook? Where's the spare key to the car? Is any of your stuff valuable? And by the way, did you make any final plans? Now, right now, I suspect that some of you are saying, why'd you reinvent the wheel? There's books on this. There's websites for that. There's apps. All true. But did I think of that when I started? No. I console myself by thinking that none of those things existed 15 years ago. And if they did, please don't tell me. I do have a few samples of these things. Website, helpful books. Books you might even call sublime helps. This is a work in process. So you see I have some updating I want to do to our white binder. And then there is the ridiculous. Oh shit, I'm dead. there are lots of helps out there. I think there's a lot more than there were when I started this. But anyway, our white binder now has 22 sections to it, and quite a lot of relevant information that I think Keith can easily access. I do have a handout for you that some of my colleagues are going to distribute now. And it is simply a list of what those 22 sections are. Yours can be different. I hope that you have already done some of that work. You don't have to do it all at one time, but I do believe that those are topics that your family is going to want to look at. I've also included a sample page, the page from our book that talks about insurance. We have home insurance, life insurance, liability insurance, and long-term care insurance. And if you don't have long-term care insurance, that would be my recommendation that you look into that right away too. So here's my conclusion. Find a good attorney. Find somebody you trust. Find somebody who will keep it simple for you. Determine what other information is important to your family and how it's best for you to report it to them. And tell someone's, not just one person, a point person in your family, your executor, a good friend, tell them about your binder, where to find it, and what it contains. Make yourself a promise to update it at least once a year. Set an appointment with yourself on your birthday, the summer solstice, the 4th of July, whatever it is, but do the task. And full disclosure, I have emailed the contents of this book to my son. I mean, I know him, right? I believe it is so important, not how you do this, but that you do that. And then I believe you will rest in peace. And the door prize, there are 2 door prizes, and they are these 2 books from someone to choose after our question and answer.
I'm not sure if I should ask if Charles has any, do you have anything you want to add to that?
No, I thought that was all good. All good.
So now we're going to try to answer, as many questions as possible. I should say that listening to that, I'm guilty of not doing 90% of those things. And my wife is constantly asking me to do a lot of what Arlene just said.
Listen to your wife.
Now, it's also listen to your children, because our children watched us go through this. And, you know, it also comes down to one of the things you didn't mention, which is decluttering, because I get that about once a month. You know, why don't you get rid of all of this stuff, right? In our attic are still all my lecture notes and all of that, right? And they're all paper and all the stuff and all the rest, and class notes and all the rest. And our daughter simply said, if you think I intend to go through it the way you did for Grandma, etc., you're nuts. I'm just going to throw it all out. So I think a lot of that about where it goes and who you want it to go to is a decision that's much harder, but I think is also, you know, needs to be on that list. We have questions rolling in, and oh, you already have one. Okay. I didn't give it to you. Somebody else did. Some stranger gave it to you. Pardon me? I think, did everybody get a handout of Arlene's? That's the first question. They're still there. There's only 2 left. Raise your hand if you didn't get one. We can. And by the way, I'm not quite sure how we're going to handle his program. I mean, it will all be online. We've got it in PowerPoint and PDF. So I've actually got it as a PDF as well. So I'm not sure whether we're going to do it by posting it on the SUAA site. Probably it'll be there. So those of you who didn't take good notes and remember all the asides, you're fine. Otherwise, you're going to have to remember what you didn't do when you were in school. You want to answer your first question?
Sure. First question is, what can you do if you have a 403B with respect to reducing taxes? The IRA charitable rollover just provides to IRAs. So if you've got a 403B, you've got to wait till you retire, and that's paid over into your IRA. But until then, just keep deferring, keep deferring.
That's pretty good. Here's another one. I would have probably asked this as well. How do you find a trustee when you don't want to use the family? And apparently it says, do not want adult child to manage a lump sum inheritance. I'm not sure if those are two separate.
I will share with you that I've had a number of experiences where people who were named executor or trustee said to me, you know, I always thought this was a great honor, and it is. But as you've heard before from other folks and people shaking their heads, it's a lot of work. I also, pertinent to this question, you can always name a family member or an attorney or someone. And you know, I have a corporate fiduciary background. They do charge, but in certain circumstances, the best thing they can do is say no. I had a situation a number of years ago where uncle was named as trustee for his niece and nephew, and he said, Charlie, I'm having a very hard time saying no to kids I used to bounce on my knee. And I said, that's why you need a corporate fiduciary. Let them be the bad guy. And you can also, you can set it up in such a way, your attorney will help you do this, where you can name a co-trustee, a corporate fiduciary, and a family member. And the family member has the right to either overrule or remove the corporate fiduciary. And the corporate fiduciary can live with this. This is done all the time. So I think the best thing to do is you know, someone you trust. I've had situations that it could be an attorney, but you want to make sure that attorney's going to be there. I mean, I just did an estate plan for a woman, and she wanted me to be her trustee, and then she came into the office and she looked at me and she said, boy, I was really hoping you'd be like 43. And I said, me too.
I'm trying to sort these out. There is a question that I'll ask. You know, somebody also asked about choosing trustees. How do you choose one? And I think Arlene described it as probably her son. What happens when you have more than one child?
Well, we did put our son as the first trustee, but we have two more successor trustees because our attorney reminded us that our son may not want to do it at that time, and he can refuse. And so I spoke with two other individuals who all agreed to do that, and I did explain what kinds of things would be involved so that they were not surprised.
I think you talked, I have a situation now where a couple contemporaries of mine, and they said, all right, you name Brian for the property power of attorney, but you name Cece, their daughter, for the healthcare power of attorney, because we know Brian's going to pull the plug. So, but I do think you need to talk to him. I think whoever you pick, it's better to have that conversation up front now, because there's always going to be the doubt, mom didn't like me or dad didn't like me. Why did they pick you as a pick me? So there could be a number of different reasons. It could be geography, it could be expertise, it could be, but get that out on the table now. Let them know, let them have that out, if you will, because it's going to save dissension later.
Wow. It is that issue of if they're around or if they're not around, but I know I was a successor trustee, and my wife was her mother's successor trustee. We both had sisters, and there's always been that issue of why did mom trust you? You know, well, you were out of town and you were far away, and that solves the problem. At least that's an answer, but it isn't always, and it's, you know, we've gone through that with our daughters. That's why I asked.
They should hear it from mom. They should hear it from.
Yeah, I mean, it's like, well, you're pretty good at numbers and all the rest, and you're much more organized. You're sweet, but flighty, or something like that. That's kind of hard to tell your children, by the way. I think.
Okay, sure. So is $100,000 rollover each year or a total? It's $100,000 each year. And once I said it's a married couple, it's $200,000. Second question is, can long-term capital gain come from a qualified annuitized account? What I'm assuming here is it's a commercial annuity. No, that's when you pay that, you can't pay it out of there, and there's income taxes due on that, and very rarely is there long-term capital gain. So, you know, you don't want to use a commercial annuity to fund a charitable gift annuity or a charitable gift, because there's income tax consequences due. And I just had a horror story with this where a planned giving officer used a commercial annuity, recommended to their donor that they use a commercial annuity to fund a charitable gift annuity. The good news is they got a deduction. The bad news is that there was income tax due and they didn't have the money to pay the income tax. What's this?
Yeah, you might want to read that.
Okay, required processes for required minimum distribution of IRA to be designated to a qualified charity. Unsuitable online forms. Don't use the online form. Call the broker, whoever, and call the broker first, because they're going to have to from there. The other thing I would do is also call the charity, let them know it's coming, so they can be looking for it. But as I said, you call the custodian, name, address, tax ID number. Charity, it's either online or they're happy to give it to you. And then call the charity and see if there's anything else that you need. The other thing I would suggest, if you're going to do this early in December. Don't wait till the 21st or the 25th, because it's going to come out later, and it's going to count for the next year.
This is one that really is for you. I think this is the wording of the question, which is. What are the considerations, or what should one consider if you're a non-U.S. citizen? Are there any effects on any of these issues?
Well, you still get the exemption amounts, okay, and you still have to file an income tax return, right? So those things should still be applicable if you're a non-U.S. citizen. But it's always best to seek your own financial advisor.
Yeah. If I'm married but want to leave everything to my kids, God, I won't go there. No editorial comments. Is that possible? I think it is, but. And what are the consequences? That isn't in the question.
It depends. As I was telling you earlier, right, when before I became a lawyer and people would ask me a legal question, I had a 3-word answer: I don't know. Now that I'm a lawyer, people ask me a legal question, I have a 3-word answer. Well, it depends. So, if I am married but I leave everything to my kids, is that possible? It can be done, but I think you need to have an agreement. Maybe if you've got a prenuptial agreement that says this is what you want to do. I said by statute, the surviving spouse is entitled to a share of inheritance. I think the important thing here is this your first marriage, second marriage? I will tell you, you got to be careful about beneficiary designations. I had a situation recently where we found out the decedent had a retirement plan. We couldn't find the plan. We wrote back to the sponsor and found it, and we're looking for the papers, and she had been divorced 20 years prior to her death. And when the husband went to the ex-husband, and he said, oh, well, you know, the kids should get it. When we found the plan, she never bothered to change beneficiary designations. He was still the beneficiary designee. And when he found out how much it was going to be, he decided to keep it. So contracts will have power. So you want to make sure there's certain states, like Illinois will automatically cut off the rights of a deceased spouse. But certain states, this was in Minnesota, and it didn't. So you want to make sure, and that's why this beneficiary designation is so important. But I think the only way you can probably disinherit a spouse is if you have a prenuptial agreement or an agreement that says this is what you're doing. The other thing is I've had situations where people are going into a wedding, a marriage, and they'll do they'll set up a trust for themselves, and there's an agreement that anything that was in that trust before I got married, that would go to our subsequent children, but you won't have a share in that.
You wanna, there's a couple of.
Sure. So how do you go about finding a good estate planning attorney or a good lawyer that you can trust? Full disclosure, right after the shock that I got from our 4-inch binder attorney, when I was at church the next week, our church bulletin has a bunch of ads on the back. And one of them was a specialist in estate planning, and she's wonderful. I'm happy to give you that recommendation if you wish. But I do think the Chicago Bar Association, the Illinois Bar Association has lists of specialists, and there are rankings. Is that right?
Yeah, but I think that's a good source, but I would suggest go to neighbors, go to friends, ask them if they've done this, who have they used, what is their recommendation. You can go also to your favorite charity. They have a list of lawyers that they've dealt with, and the lawyers are bound by confidentiality. They will not tell the charity if it's none of the business because you're the client. So there's a number of resources that you can use, but I would say the best is neighbors and friends that have gone through the process.
And interview them. Don't think just
Yes.
because you made an appointment and talked to them, you owe the attorney your business. No,
Yeah.
you have to really, really feel comfortable. And I think this is a kind of follow-up question too. I'm just beginning with a will. Where do I start? What's a basic first step?
I think the basic first step is to gather your assets. What do you have? Who would you like it to go to? And then go from there. I think what I do is I run the numbers. I show them if you die tomorrow, this is what happens, and is this what you'd like to happen? And then it comes back. I like to reduce these taxes. How can I do that? But I think the primary thing is as I said earlier, think about those first questions. You had a large sum of money, and what would you like to happen with it? And that's your large sum of money, and what would you like to happen to it? And the other thing too is run those numbers. I had a client who one time shared with me, he says, I knew my life was getting better, but I didn't know how much better until I saw the numbers. and so I think that's the one true way of finding out.
I'm going to try this one. I think it's for you, Charles. Can you give someone the power of attorney for property that won't expire upon one's death?
Well, it will expire unless you name it as executor.
Okay.
Yeah, it will, because usually they will expire, but unless you name them as executor. That would be true.
Oh, okay.
If one spouse goes into a nursing home, should he or she shine his share of the house to the other spouse? There's another 3-word answer. It's too late. First of all, to qualify for Medicare or Medicaid, there are income requirements and asset requirements. The house is exempt, so that should be okay. But the other thing is, if you're doing this, if they're going to look, there's a clawback rule. Well, they'll look at transfers 5 years prior to going into the nursing home. They'll want to see what happened there, and then you want to make sure that you can show that if indeed you've done that, it was for value, true value, it wasn't just a gift.
Yeah, I remember someone in my department, and there was all this discussion. She was telling us about having tried to sell off the mother's home because that was the only way when they were putting her in a nursing home that would be covered. I never really understood it. I was much too young and naive and didn't understand that one day we'd have to deal with that as well. Differentiate between the transfer, I think it's transfer upon death instrument and a land trust.
Sure. A land trust is an arrangement where you name a corporate fiduciary to hold the title to that property. Okay? And then upon your death, and you'll have you'll be the beneficiary, or you can do the beneficiary, you and your spouse, for example, or whoever can be in joint tenancy. And then you can name successor beneficiaries. And title will automatically pass on the death of the original beneficiaries. So, for example, Chicago Title Land Trust Company does that for you. Your own revocable trust can do that for you. So that's not necessarily a land trust, but a revocable trust. Transfer on death is, you can do this with real estate, you can do it with brokerage accounts, you can do it with bank accounts, where it says, upon my death, it goes to X. For real estate, it's like I've looked at this, but it's like it's almost, you should just do it in probate because it's so much easier and it's going to cut off the claims of creditors. So I'm not a big fan of the transfer on death for real estate, but that's just my opinion. There's other ways to do it, either with a revocable trust for yourself, same thing will happen, or go to Chicago Title Land Trust. They're the ones that do this, they're professional. They'll do it for you.
I think you've got, there's one here about
Okay.
insurance.
Do you need the actual life insurance policy document or just fact sheets for insurance? Both. I have put our original policies into our firebox so that it's easy to find should the insurance company say, we need you to give us the original document. But I do take copies of those with us, and I have copies of those in our white binder. Here's how helpful it was. We were in Colorado visiting our son. We needed to take his car in for repair. We wanted a rental car so we could go somewhere. The guy said, where's your insurance? In my car in Chicago. But I showed him the copy of the insurance policy that was in my white binder. It was fine. We got our car, we traveled. And so I would say you want to keep copies with you or in your white binder, but the original, protect that and make it easy to find.
I'm worried about Arlene when they lose her luggage. I don't know what happens on these trips.
I only do carrying.
Okay. Short trips, but when you take the long ones, it's a problem. I'm not sure who should answer this, but basically someone's asking about, they don't have long-term care insurance and are concerned about going to a nursing home and that the way that the patient's assets are spent as a consequence. I think it's as a consequence. I'm not quite sure. I can't read the last line. I apologize.
Don't have long-term care insurance. I'm concerned about going into a nursing home and the way patients' assets are spent. Well, you've got to spend down before you can go into the nursing home, and then you qualify. So you're not going to go in with a bunch of assets. You're going to have to either disgorge, pay the nursing home, or get down to a certain limit. And then you're on Medicare, Medicaid to get those benefits. I can answer this one.
Okay.
There's a note that the federal exemption amount by law will be reduced to $5 million, adjusted for inflation in 2026. That's true. I will also tell you that there is a bill pending in the House Ways and Means that would reduce that to 3.5 million. And whatever is your political persuasion, someone's got to figure out how to pay the deficit down. And if a wealth tax can't do it, maybe the estate tax should. And the other thing too is that it's going to be a trade-off, because on the estate tax there's something called step-up in basis. So let's assume that I have stock that I bought for $1,000, and when I die that stock is now worth 10. that stock is includable in my estate at 10. There's $9,000 of gain that was never taxed. Step up in basis. And so even these were in 2010 where it was the zero estate tax, they eliminated the step up in basis. They said, okay, we're going to eliminate the estate tax, but we're also going to eliminate the step up in basis. So the argument for the estate tax is this gets untaxed capital gains.
That's probably frightened a whole slew of people. But all right, someone had a comment, and I think it must be based on experience about unclaimed property from any state you or your loved one lived in, and what it takes for the state to compile what was out there. I don't know if it's you or the state.
Well, the state will publish, the treasurer's office will publish, and you can go online to see if someone you know has unclaimed property in that person's name, and then you just contact the state treasurer, and they're going to want documentation to show that you're the appropriate person to get it. So if it's a will, if it's an affidavit of heirship, but it's the state that compiles this information, and that's really the only way. Otherwise, after X number of years, it reverts to the state as unclaimed property. But it's the state that's compiling it. It's your responsibility to find it. So if you're the heir of someone who lived in certain states, go online and check.
Has anybody ever gone through that process? It's tedious. We kept getting a notice from the state. It had to do with my mother-in-law, and we finally called. And I eventually sorted out that you have to send in forms, and it's true. You have to send in so many documents, you may just say, is it worth it? In this particular case, it turned out to have been a check sent to my mother-in-law. She hadn't received it, so they'd issued her another dividend check. And it was going to cost us more to collect the money in terms of all the forms. I mean, you had to send everything. Copy of the death certificate, proof showing my wife was the executor and that she had the power and all the rest. By the time you're done, you have to be sure that there's enough there to do it. I mean, if it had been, a lottery check of reasonable amount, I might have done it. And I think there's a term been thrown around, and I'm going to ask this question because you ought to explain it. The difference between executor and trustee.
Okay. The executor is the personal representative under the will. Okay, so that person derives his or her power from the will. A trustee is the person who is the personal representative under the trust. A will only becomes effective upon someone's death. A trust can become effective prior to death. And the trustee, there's a three-part agreement for trust. There's the trust property, the corpus. There's the trustee who has the title, legal title to the property, and then there's the beneficiary. And the trustee holds legal title for the benefit of the beneficiary and owes a duty of loyalty and prudence, loyalty and care to the beneficiary. But there's two different documents. Executor is the will, trustee is the trust.
I'll follow that up with what are all the duties of the trustee? Is it completely spelled out in the trust?
Well, it'll spell out the trustee powers, and that's where your 3.5 inches come in. But primarily, the duties are to gather the assets and make the distributions and pay the debts and pay the taxes. I've got a 2-page sheet that I give to my clients that shows what those duties are. I've got a 2-page sheet that shows what the executor's duties are. It's work. It's, as I said, it's honor, but it's work. And the other thing too, I mean, you could be named as executor or trustee and have an attorney do the work for you. They'll be much more conversant in what's going on.
Do you have any? You've gone through this. So. Do you have any comments on that as well?
I think that's excellent advice, yes. And I think it's important that you do have an open conversation with either of those individuals so that they understand what you are asking them to do.
I'm looking, there are a few others. Someone asked about what should we do with our savings bonds, because they don't need the money right now, and if they're, it really says they're between 25 and 30 years old. I think I would say initially check, and you can do this online with the US government. You can actually go to a site, put in literally the serial numbers. It'll tell you the exact value at present, and in a number of cases, it will already tell you that you've, I guess, topped out. I won't say bottomed out, meaning that it's no longer earning any additional interest. At which
30
point,
years.
yeah, on 30. Yeah, and it depends on the series.
Yeah, and I would suggest, remember we talked about income in respect of decedent, savings bonds are those. You cannot name a charity as the beneficiary of savings bond, but you can put in your will that any savings bonds that I have payable to X, Y, Z, or whatever your favorite charities are, you're going to avoid the income tax that is payable by your estate, and you've made a nice charitable gift. So once again, you know, where do those assets come out of? This is a cost-effective way of making that charitable gift, and it saves your heirs income taxes on that.
Those who have government savings bonds, and if they're no longer, you know, they're not the old, bought them for $17.50 and they're now $25, or all those old ones, $37.50 became $50 or something. There's a lot of interest on some of those, and it's a tremendous amount of tax that you don't realize is there until you look and see just how much they've appreciated. Are there any other questions? We run out of cards. Yes, please. I think there's microphones if anybody,
Outside, if you'd like to have a question.
unless you just want to yell it out.
Yeah, I just wanted to ask,
So yell louder.
Yeah.
Please go to a microphone.
Go to
We
a
can't
mic.
hear you up here.
Yes. Oh, that didn't work.
what state laws decide, what state dictates what happens with the estate? The state where the person is deceased, or the state where the heirs live, heirs live, if they don't live in the same state?
The laws are determined by, number one, where did the decedent reside? And number two, where did the decedent own real estate? So let's assume I own real estate in Wisconsin. Unless I do something with a trust or in joint tenancy or titling, I'm going to have to open up two estates. One in Illinois, where I reside, and one what they call ancillary probate, to pass title to property that is in Wisconsin or another state. But it's determined by the decedent, either A, where they reside, or B, where they own real estate.
Yes, please.
I have a different twist on something similar to what she just asked. A friend of mine passed away, and I was subsequently named administrator through probate court. And I want to know, how long does this title last? How long do you have to finish all of the items that are in the packet that need to be taken care of as a result of her death? And she did own property in another state. And her heirs actually live in Europe. What should I do?
Get a lawyer. Get a lawyer. No, here's. So remember I said that probate is determined by either the will, that's the executor, or
state intestacy law. So if there is no will, then you're named as administrator. So you have a responsibility to go into court and get named as the administrator. Once you are named as the administrator, the court's going to tell you, we want an inventory by such and such a date, or we want a final account by such and such a date. So those are your responsibilities, to gather all the assets, pay the debts, and then make the distributions, and you give an accounting to the court. There's also provision if you have heirs in foreign countries, there's some publication rules that you have to abide by to somehow, if you know where they are, or give state representative, not when I say state representative, embassy or like, but there's requirements, reporting requirements. I would not, don't try this at home. We are professionals. I would see an attorney to get this stuff done, because because you're on the hook. It's your responsibility to do this. Now, you've given a bond, but those are your responsibilities, and those are your responsibilities.
Well, I had an attorney, and we distributed the bulk of the property, but there still remains a piece of property out of state, and we did not pursue the administrative duties in that other state. So I need to go back to the attorney again and finish taking care of that last parcel of property.
It depends. I mean, if that property, I've had situations where we've had real estate outside, and in this situation, everything went to the surviving spouse, and she said, that property wasn't worth anything, so let's not bother with it. So I think your responsibility is, A, how much was it worth? And B, who do you distribute to? And you might want to do something to protect yourself with those heirs, so you don't want them to come back and say, hey, we found out that there was property in X, and you never pursued it, so we want our share, and you were negligent.
Well, the heirs know the property is there. They apparently have no plans to come to the United States ever. The property is worth 2 cents. It's not developed, not probably going to be developed, but they want to keep it because they think maybe one day their grandchildren may want to claim it. So do I have any legal responsibility to continue to pay the pittance of taxes on it and continue to keep a small account open in case they want to pursue it? I have no legal contract with the heirs.
Yeah, I think, talk to your attorney, but there's a way that you can pass title to them and let them have it directly, so they'll get 1/6, 1/8, whenever. So there's a way. You're going to do an administrator's deed to that. If they want to keep it open, and you're going to need an attorney in that state to do that for you. And I want an administrator's deed where I can deed representative shares to these folks, record it, and then you're out of the picture.
Thank you.
Hi. In the presentation earlier, you said that to avoid the online forms. Why?
Well, as I mentioned, that there can be, it doesn't do what you want it to do. And number two, make sure it's executed properly.
Okay. Follow-up question. Because I saw on the TV, on the Susie Orman show, and I bought the golden form, whatever is that, because I'm trying to avoid paying lawyer big amount. They're charging big amount. So I asked somebody told me that just fill up the form and have it notarized. And we have in our department, we have in a notary, and I asked him if it's okay. And then I asked how much he's going to charge, and he said it's free. Is that correct?
I'm not going to tell you anything that's unauthorized practice of law, so you make your own decision on that regard.
No, not yet. I haven't done it
No, you
yet.
make your own decision on that regard. Sorry.
Oh, okay.
Okay, before everybody leaves.
Thank you.
Thank you. Before everybody leaves, the raffles, and I'm not sure which one. Oh, I'm sorry. Go ahead. I didn't realize there was one more person.
Before everyone leaves, I would also like to get your information for your trustee. Before you said that you had that available?
I think you
Oh,
meant
yes.
Arlene.
Yes, so
Oh, my
I would,
attorney?
right, your attorney, that you were,
That'll be off topic.
I beg your pardon?
She'll do that out.
Okay.
Okay.
And then I have a
Go
question
ahead.
from the floor. I'm reading this. If you're still legally married and you have your child's name on your accounts, can your spouse still get it? There's no property involved, just savings, checkings, and an IRA.
She wants to open, well, it's gonna pass outside of probate, but, I'd still be concerned. I'd still be concerned.
So she needs a lawyer.
Yeah.
Okay. Thank you.
Okay, those of you who have been waiting breathlessly, I'm not sure which is going to be which, but if you've still got your stubs from signing in, the first one, I think the first few numbers don't matter. So the last three numbers, 637. I'm worried that everybody left.
We'll keep trying.
We'll try it again. All right. Well, we may have to keep pulling into the. Is it a pumpkin? 631. Okay.
Just come and choose.
Just come and choose whichever one. I guess 637 missed out. So, Marcia, you won one.
Hello, Miss Marcia. It's good to see you.
429.
Better.
Must have been an early arrival. Well, we're just going to go through this entire pumpkin pretty soon. 416. Somebody has to be here. Well, we're working our way through the audience here. I'm now going to take two just in case. 425. Pretty soon I'm going to ask you to just raise your hand. 431. Okay.
And as a reminder, if you have not picked up your Halloween chocolate outside, we have it on good authority that chocolate is good for your heart. You want to live long enough to make sure you put all these documents in place.
Okay, with that, I don't know if we have any other closing remarks from Michelle, but thank you all.